James Ellis Arden is an attorney based in North Hollywood, California, who works on litigation and appeals matters involving civil procedure and attorney malpractice issues. He is rated AV preeminent by Martindale-Hubbell. Mr. Arden writes and lectures on legal malpractice, technology, and ethics. He authors the Techno-Ethics column in GP Solo magazine, published by the ABA General Practice, Solo, and Small Firm Division. Mr. Arden is a member of the Association of Professional Responsibility Lawyers, the Professional Responsibility and Ethics Committee of the Los Angeles County Bar Association, and the California State Bar Committee on Professional Liability Insurance. As he states, in the olden days, he studied psychology and computer programming. Mr. Arden would be happy to speak with anyone who may have questions about credit damage cases or other issues. He can be reached at persuade@ardenlaw.com or by phone at 818-752-4848 or on his website, www.ardenlaw.com. George Finder is a court-accepted credit damage evaluator and has provided consultation, written and oral reports, and testimony since 1995. His practice is limited to credit reputation damage in contract, tort, and family law. From his Southern California office, he offers services nationally. Mr. Finder is an associate member of the Los Angeles County Bar Association Litigation and Family Law Sections, the San Diego County Bar Association, Consumer Attorneys of California, Women Lawyers Association, and Forensic Expert Witness Association. Mr. Finder may be reached via his website, creditdamageexpert.com, or by email at creditdamageexpert@gmail.com.
Hi, I'm James Arden. Jim is preferable, but I'm here with George Finder, and we're presenting a program on credit damages and how to apply them in cases. My co-presenter here is George Finder. He's one of the pioneers in credit damage. In fact, I learned quite a lot when I first found out about this, which was from him. He's got more than 20 years experience in this field, certainly one of the pioneers, and he's going to be giving you a lot of information that I found really, really valuable and still do. George?
Hi, this is the real George Finder, and I met Jim when he retained me in a case several years ago, and we've stayed in touch on additional cases. And in 1995, I was providing CLE presentations for the state of California and a couple of other states. And at one of those presentations, an attorney came up to me and told me about a client that he had that had been defrauded out of a piece of property by her real estate agent. And fortunately, the real estate industry has a fund to deal with that sort of issue. And everything was going very smoothly until it came to the issue of the economic damage that was going to be inflicted on the client, who was suffering from foreclosure, late mortgage payments, and other negative remarks in her credit report. And and that's how she found out that all of this had happened to her. And then once it was being adjudicated or dealt with in court, she discovered that she could not borrow the way she had borrowed previous to this experience. And she was furious, and she wanted to be paid for that damage, just as they had paid for the other damages. Well, the insurance company said that what she was asking for was not measurable and could not be measured, and because of that, they could not or did not have to pay her. And they offered her, just as a general release to include credit damage, they would pay her $4,500. And she thought that wasn't enough. She didn't know how much was enough, but she felt very strongly that that wasn't enough. And so the attorney asked me if I could help with developing a dollar amount and an expert opinion. And at that point, I was not an expert witness. And I told him I would be glad to be his expert witness if he told me what an expert witness was, which he did. We had a very good relationship. And approximately a year later, we wound up in arbitration, presenting my details and others. I had submitted a written report, and the opposing counsel had tried to disqualify me, as I had never worked for a real estate agency, a mortgage company, or had anything to do with any of that type of employment. And the only thing that allowed me to testify was that for 6 years I had been doing seminars, CLE seminars, for the California Department of Real Estate, which is now the Bureau of Real Estate, since 1991. This is 1995. And in 2002, I started doing credit damage items, presentations. And based on that, I was conditionally accepted as an expert witness, because all the other experts on the other side had only taken courses, had never given courses. So I testified, and my measurement of the damage for a 7-year period was between $31,000 and $35,000. And I presented and survived examination and cross-examination. And the upshot is that the arbitrator ruled in favor of my client in the amount of $33,000. And I had a whole new career, which I've been doing ever since.
So why are we talking to you about credit damages? It was fascinating to me when I found out about this, and I will tell you about that in just a moment. But this is why it's important. As litigators, particularly, and as the plaintiff's attorneys, of course, you're always looking for a new cause of action, if possible, something to increase the value of the case. Well, credit damage, when I understood what we're talking about, it's better than a brand new cause of action from a plaintiff's perspective. It's a remedy that can apply to almost any cause of action. And in some cases, as you'll understand later, hopefully, it could be a cause of action all by itself. But it's a wonderful thing from a plaintiff's perspective, because if you can increase the value of the case, that's where all the money is coming from that your client is going to be compensated from and is going to pay your fees. So from a defense attorney's perspective, they need to know about it in order to counteract it and save their clients from having to pay damages that aren't warranted for credit damage. Now, my experiences in is litigation, and almost 30 years of litigation and appellate work. I've handled a lot of different kinds of cases. I'm now focused mostly on legal malpractice and ethics matters, and I do a lot of work for other lawyers. But I found out about George from my client in a case. I was representing someone who was a talent, worked as a talent agent, and was accused of violating the rules that or for personal managers. It was actually a legal malpractice case I was involved in because this client had an attorney who was representing him in a claim involving the Talent Agency Act violations, and lost the case. We thought through negligence. He just never understood the right theory in the case, was my thought. So I take on this case for this very intelligent client. We're talking about expert witnesses, and he brings me George Finder, who he's found. And I'd never heard of credit damage. It was new to me. But when I understood it, it made perfect sense. I mean, if you have damage that's caused by a tort, or even by a breach of contract, but the damage that prevents any kind of, or excuse me, not prevents, but causes financial harm, any case where you have restricted income, people that can't pay their bills, there's a potential there for credit damages. And so in this particular case involving the Talent Agency Act, the client had lost millions of dollars in commissions through a claim, the claims that were involved in the underlying case. And his business was wiped out because of it. So he had lots of credit problems. And I never would have, that was my first exposure, as I mentioned, with the idea of credit damage. And it was wonderful because I understood, even if it applied in this case, all the other cases it could apply in any kind of injury case where someone is unable to work, their employment is cut off, or they have bills they can't pay. In the case of a breach of contract, it could cause financial harm to someone where they can't pay their bills, or to a business that can't pay its bills, because credit damages can inure to individuals and businesses. There's no reason not to let both recover where they're warranted. You've got under in California, and I'm only licensed in California, but I believe the statutes are going to be pretty similar in a lot of places. We have a tort statute here, it's California Civil Code Section 3333, that lets you claim as damages any kind of a breach that flows from a tort, not from arising from a breach of contract, but any other tort. So that would be like a car accident or any kind of injury case. It could be an employment case where someone, that is a workers' compensation case, where the worker's out of payment, anything that causes these types of damages. And if it is from a contract that you're claiming, then you've got the old rule of Hadley versus Baxendale. As long as the credit damages are flowing approximately from the breach of contract, you can claim credit damages in a breach of contract case. So you've got that for contract cases, and you've got statutes like Civil Code Section 3333 for all the tort cases. Now, the credit damage expert is an expert, can be used as an expert witness like in any other kind of expert witness case. But there's some differences because, there are a lot of experts that can reconstruct an accident. There aren't nearly so many experts that can talk about credit damages. When I met George, he was the only one. There are a few others I'm aware of, but there aren't many. And so in a common expert witness case, you might not worry about your expert witnesses until it's time to disclose them. You're probably making a mistake. You should get expert witnesses if you're going to need them. You should get them involved as early as possible in a case, because that way you can get help with the pleadings, with the strategy in the case, even with framing discovery. And in a normal case, whereas you might have an expert on hand to consult like that, but you're not disclosing them until you have to, and maybe not then for other reasons. But I had another case where I had involved George early on, and I was trying to get the case settled early on. I didn't want this case to go to trial. It wasn't in anyone's interest to try this case because it was going to be very expensive to prepare. And seemed like the damages were cut and dried, but I knew that the other side didn't think the damages were nearly as large as I did, representing the plaintiff in that case. So I had sent a letter early on to opposing counsel, and I mentioned I'd retained a credit damage expert because I was pretty sure that this other attorney had never even heard of the concept, just like I hadn't some years before. And I wanted him to take a look at this letter and the reference to credit damage expert. I hoped he'd notice it and say, whoa, what is this? And try and figure out, wait a minute, this is a dimension of the case I've never heard of. So it can be really helpful to get an expert, especially if it's a credit damage expert involved early on. In that other case I just mentioned, even though we didn't get the case settled right away, it did settle later. But in the meantime, I was able to send out some discovery. I know there really isn't any killer discovery, killer interrogatories, but that's what I felt these were, killer interrogatories. And so I'd like to believe that it helped get the case settled. It did get settled, and I think my client was very happy with the outcome. I don't believe it would have happened if we hadn't brought up the credit damages, because that was a whole new dimension that the lawyers had to deal with. And with that, I don't even know if they were able to pay as much attention as they would have otherwise to the other parts of the case. But it worked out really well. And so I would urge you, anytime you have someone with financial difficulties that might have affected their credit, and that's in a case where you don't have direct evidence of some threats to credit. Some cases, you're going to have a client who gives you, talks to you about the telephone calls they've been getting or the letters they've received threatening damage to credit in different ways.
Can I jump in here?
Absolutely.
Good. I wanted to specify the typical losses that I personally look for in a qualifying credit damage case. And that's qualifying is something we'll get back to in a little while. But I'm looking for damages that result in increased out-of-pocket costs. They can't buy what they used to buy as they used to buy it as a result of the loss of credit. And that loss of credit capacity is a very major damage, because if you're used to using credit, losing it is emotionally and financially harmful. Part of the loss of losing credit capacity very frequently is the inability to replace with new credit the amount or similar amount of credit that you had before at any interest rate, at any charge. So it's not just a matter of calculating, did the interest rate go from 5% to 25%? How do you calculate the cost of not having any credit when it was an important part of your lifestyle or your business? And that's what a credit damage expert should be able to do. The other thing is, if the credit suffers, one of the reflections of that is the credit score. And when these injuries, remarks, derogatory remarks appear on a credit report, it's not unusual, depending on the kind of job that someone has, for a reduction in job opportunity. They may lose the job they have simply because they no longer qualify based on the company's requirements. And one of the very simple examples of this is the military. If someone is going through a divorce, and as a result of the activities and behavior as involved in the divorce, one party will intentionally or unintentionally do something that reduces the credit score of their spouse. And in doing so, they will change their security clearance level I've had this happen several times, and they will go from the job that they're used to having to something of much less responsibility until they can straighten out the problem, if they can straighten out the problem, which is a whole other seminar. So again, we're looking at increased out-of-pocket costs, and that can be due to denial of credit that would otherwise be available to the client. That is a reverse, in my opinion, a unique but common kind of increased out-of-pocket cost. There is the loss of credit capacity, which can be with real estate or can be with credit cards. And certainly the loss of credit expectancy is the reduction or inability to obtain new credit at any cost. So if all of a sudden your client had $50,000 in credit cards and now has $10,000 in credit cards, that would be a very good example of loss of credit capacity. If a client was wanting to move or refinance their home, as an example, because they're in a high interest rate note, or their interest rate is about to adjust, and so they want to get out of that particular mortgage. If they can't get out of that into a lower mortgage, that is an example of increased out-of-pocket costs. And that's all I have to say about that at the moment. Typical cases where credit damage may apply include personal injury. Let's assume that it's a serious personal injury matter where there is loss of income due to medical injury and treatment period. Typically, if the case has the injury is serious enough and there is at least 60 days of loss of income, typically during that period, the client is not paying all their bills because they're not bringing in as much money. If they've gone from a two-income household to a one-income household, or even a single-income household, because the income is less, they cannot pay their bills, that injures their credit. Improper real estate transactions, certainly mortgage modification with its dual tracking, and other improprieties that are being revealed almost daily in mortgage modification. I have been very successful in working with attorneys who not only get the property in an improved relationship, but they're able to use damage as a leverage to get that improved relationship and or a reduction in the balance, if there is even a balance. In my most recent case in New Mexico, the client got the house at a 50% reduction of their balance, plus they got cash from the lender, and of course the attorney's fees were paid out of that. One of the types of fraud that comes up now and then is identity theft. Identity theft is a very real situation. I was involved in a case where the client was defrauded. It was an African American. My client was not an African American, and it was a situation where because of the identity theft and confusion, the client, who was a licensed professional, had his license to practice suspended, which caused him loss of income, and that brought in an aspect of the case of economic damage. So there are almost any place where the desired result is write a check or cover expenses through that check. it's an economic damage, and I would say, in my experience over the last 20 years, that there is a very high probability that the economic damage has caused credit damage. One of the other areas is health insurance coverage. If the rescission of health insurance causes the client to have to pay bills either out of other funds, which were not intended for that, which could be a retirement account, it could be business cash flow. In one case that I was involved with, it was business cash flow. The health insurer rescinded the coverage on twins that were born, and one of them had a medical problem. The father, of course, wanted his children to be as healthy as possible, and he literally bankrupted two very successful businesses because he was so emotionally distraught, and he just couldn't pay attention to the businesses. And he went through the proper documentation for that purpose, and we got him not only reinstated under the policy, and of course the attorney did that, but based on my report, we were able to get him compensation for the businesses that he had to bankrupt. And of course, there's the contested divorce. I touched on that a few minutes ago, but if it's a contested divorce, the probability is that one side is going to try to harm the other side. And the most common result is that the lower wage earner winds up in a poverty situation as opposed to a more equitable situation. And my report can improve the balance financially. My first divorce matter was a husband and wife with two children. The husband decided he didn't like his wife anymore. He wanted his children, but he didn't want the wife. And so he took their joint accounts and ran them up to the absolute maximum, and then he bankrupted himself. That still left the lower earner with all of the bills and all of the unpaid, because the wife did not have the financial resources to pay the bills, which was well known to the husband. And based on my report, the court awarded the client every penny that I suggested that she was entitled to, and a little extra. And so that was a wonderful case of a marital partnership that I was able to help the future of the children and the wife. I like that feeling. Business partnerships have the same issues as marital partnerships. There's more legalities involved, but I've been involved in a couple of partnership dissolutions where the partnership agreement included a protection of inflicted credit damage by either partner on the other, and that was the basis on which we could recover the damages to the, what I will call the harmed partner. Same procedure. In all of these procedures, from my perspective, the procedures are the same. The first thing we do is we qualify the client as being capable, based on my discovery of what they've suffered and how they've suffered it, to make an admissible and valid credit damage demand. One of the things that is important is to be able to recognize complaints from clients that should raise the red flag that credit damage should be at least addressed in the matter at hand. Um, there are really simple statements like, I can't pay my bills. I'm getting bill collector calls, and I'm getting my car repossessed, or I'm facing eviction, or foreclosure. Those are very bold comments from the client telling you that their financial situation is deteriorated, and now with the ability to qualify the case for compensation, it goes beyond the, gee, I feel sorry for you, but I don't know what I can do for you. Now you can address the issue and fully explore a solution, financial solution. I was involved in a case several years ago where a property owner's insurance claim was ignored by the insurer. This was in California, and for whatever reason, the insurance company just didn't step up to bat. So the insurer went to the property owner went to a hard money lender because he needed operating funds to maintain the building. And that almost bankrupted him. He found an attorney who understood his case, and based on my documentation of how his cost of operating his business, due to the ignorance or the non-performance of the insurance company, caused him financial harm, we were able to get the insurance claim totally reinstated and paid for everything involved, including the increased cost of money by having to go to a lender rather than to pay the insurance claim. One of the reasons that the property owner had to go to a hard money lender is because the credit report information showed that the property owner had a pending lien on the property for the amount owed, and that was resolved without my involvement. But that lien basically erased any opportunity for using the credit reputation that had been so carefully built up. Jim, do you want to talk about the credit reputation as special injury? I am on slide 15.
Absolutely. Because I'd already mentioned the Civil Code section 3333 and the rule in contract cases, Hadley versus Baxendale, and the rule of damages. But even though this credit damages seems like a new concept, it's not in the law. The several cases going back into the last centuries touched on them, and we've got some mentioned in the PowerPoint. The case of in the Bell versus May Department Stores, although that was a Missouri case from 1999, but that was a case that kind of shows you how this is a developing area. The trial court had granted summary judgment against the claims of credit damage, but the appellate court in Missouri reversed it and went up to the Supreme Court and let the case go forward. But there was the, way back in the 1912, the Simonoff case was one of probably the first to talk about the concept here.
That was in Missouri, by the way, also.
Yes, the Simonoff versus Goodman case was an early case in California here from 1912.
Okay.
And excuse me, that was the case where they dishonored a check without right, and there was the complaint that if you're dishonoring a check, it's causing credit damage. That's what the court held, that the drawer's credit suffers, and it is well known that for this injury, a depositor is entitled to his action against the bank in comparison. So they let the case go forward, and that was back in 1912. These are aspects of defamation and slander. Slander to credit is what it's called in some jurisdictions. And it can be, as I mentioned, a cause of action all by itself, as some of these cases exemplify. It is in other cases an additional remedy you need to look out for in the cases that George was mentioning, and some others of the type. You can, in fact, you want to make, as I touched on in a case that I had George involved in early on, you want to make these demands for credit damage early on, get them on the record. The judges and the courts are not familiar with them any more than the other lawyers are familiar with them. So you need to get it out there, and it's in all kinds of cases, beyond the ones that we've already mentioned. You could have credit damages from an unlawful detainer landlord-tenant case because the reporting of the deadbeat tenant is going to cause, in most cases, credit damage. Medical malpractice or legal malpractice, any kind of professional malpractice, is going to be potentially causing credit damage. You even have cases, the case I just mentioned that I had George involved in was a case involving unlicensed contractors who were ruining the homeowner's credit. Excuse me. And the first case, as I mentioned, in which I met George, was a case involving legal malpractice involving the Talent Agencies Act and those kinds of esoteric things. You could have this come up in an administrative case, a licensing case, an education case, because that's affecting the ability to earn a living in some cases. I even had a case, I mentioned workers' compensation. I had one case where it was a workers' compensation case that morphed into racketeering, and the damage that was inflicted by that was significant. So were the credit damages. And what's happening more and more is, as you've probably heard about, these cybercrime cases. There are attacks, for instance, on banks where the hackers get into the computers and lock up the whole system of computers that the hospital relies on and hold it ransom. They have to make a big payment in order to get their systems unlocked. And frequently those ransom payments are made because it's the quickest way to get back into business. Think about it. A hospital that can't use its computers is out of business, and that's killing people. So those are the things that are going on right now. And they're not just hospitals, other businesses. If your business gets attacked like that, you're out of business. And it can be a law firm. It could be another business. It could be a client's business. And these are happening more and more frequently. So
I'd like to jump in, if I can, about one of my favorite cases, and that's Scorn versus Home Depot. Talk about unique causes of action. This particular cause of action was violation of privacy. Mr. Sporn was a multi-talented, multi-business enterprise involved individual who had a wonderful relationship with his bank. And he called one day and he said, I want to borrow some more money. And they said, terrific. And they said, we'll give you the best rate possible, but we have to pull your credit report. And so that happened, and they called him back, and they said, well, we have a problem. And the problem is you have too many inquiries from one of your creditors, and it has lowered your credit score, where we're going to have to charge you more money. And Alan Sporn did not want to sit still for that, and he requested a copy of the report so he could see who was doing it. The bank shared that with him in an unusual move, and he contacted Home Depot and asked them, what the heck is going on? Why are you violating my privacy by looking at my credit report? And they told him that They weren't violating his privacy. They were monitoring his account with them. The upshot is that he did not have an account with them, and they apologized and they said, we will never do that again. And it happened 11 times so far, and within 2 weeks of getting the letter, they did it for the 12th time. That's when Mr. Sporn came and found me, and we developed a credit damage valuation, and the upshot is, and by the way, this particular violation of privacy case was rejected by about 5 dozen attorneys as having no financial value. When he found me and I developed the report, I showed that his damage, including statutory violations, was $275,000. I think the statutory valuation was about $30,000. So if you pull that away, it's about $240,000 in economic damage. And Mr. Sporn and I and the attorney went to court. We did a prove up, and the court understood what had happened, and they awarded him $930,000, including punitive damages. When a few other events unfolded, Home Depot, who was the defendant, requested after the expired appeals period, they requested that Mr. Sporn give them permission to appeal the matter, even though it was expired. And he said, well, he would do so, but they would have to put $1.4 million in escrow. And if he prevailed, he would keep the money. And if he didn't prevail, they'd get it back. He prevailed. The appeals court absolutely saw what had happened. And for a case that had been turned down by dozens of lawyers, the client was able to be compensated for $1.4 million. In round numbers, $1 million plus. And that's why when Jim says the kinds of cases that are eligible for credit damage to be addressed is almost universal for tort and for the other kind.
Let me ask. Oh, I'm sorry. Go ahead.
That's all right. Go ahead.
Well, I had a question.
Sure.
You mentioned that you were involved in a partnership dispute where credit damages was actually in the partnership contract.
Yes.
That sounds somewhat unusual to me as far as partnership agreements, but fortunately it was there. In most cases, though, you're going to have to ask, the clients some questions and things. You're going to have to look to see if there's a possibility of credit damages. So, what kind of things should lawyers ask in order to find out if there might be credit damages to pursue in a case where they're interviewing a client or otherwise involved in the case?
As part of the intake process, and I might even say pre-intake, deciding whether there's enough at hand here to do an intake, ask the client, how have you been harmed? How have you been harmed in terms of income? How have you been harmed in terms of debt level? How have you been harmed in terms of job opportunities? And the simplest way to know that, in my experience, one of the problems is when you ask the client that question, they're not going to limit their opinions or remarks to the matter at hand. They're going to tell you that in 1957 or whatever is an appropriate year, an earlier year that has nothing to do with the case, they're going to tell you they missed a credit card payment or some other thing. So the first thing to do is ask what has happened to you as a result of this injury. What was the date of the injury? And what has happened to you since the injury? And one of the simple ways to confirm that those things happen is to get a subscriber credit report, which is totally different than the free credit report that is typically offered to consumers. And when I say free, I also mean the kinds of credit reports that are used in credit monitoring service. So the kind of report that you would get, or the kind of information that you would get from someone like Credit Karma or other online providers of what they call information and indicating to you what your approximate credit score is and indicating to you what is causing it. That kind of report is not admissible for this purpose, and in my experience, for any purpose related to the courts. The only report that is admissible is a subscriber credit report, and the best kind of those, and there are about 5 different kinds of subscriber credit reports, is a mortgage credit subscriber report. And you would want that credit report to be a tri-merged credit report, which simply means you get information from all 3 bureaus. Because no matter what anybody tells you, the 3 credit bureaus are different. They have very different personalities, and their scores and their information are not identical. So you want to get the complete picture. Whether you do it as part of the intake process or confirmation that this is a valid case is certainly one way to do it. But even if that happened, let's assume that everything happened pretty much the way that the client described it, when it was described, etc. The real question is it compensable? And in another seminar, we can go into that. But one of the things one of the points in language that I always like to ask is, what, if anything, you had to sell of your own? Did you have to cash in your retirement fund or partially? Did you have to borrow from friends or family or total strangers in order to maintain your credit at its best status? Because those are the kinds of things you want restitution for. If the Jones family had to go to Ma and Pa Jones and borrow $25,000 from them, wouldn't it be nice to be able to repay the loan that they shouldn't have had to take out as part of their compensation in the settlement or opinion of the court? That's the kind of thing that I would look for, and that's again, I look for increased out-of-pocket costs, I look for loss of credit capacity, and I look for the inability to replace that credit capacity either at the same rate or at all. Those are the simplest red flags you should look for.
All right. Now, before you go into what these subscriber credit reports actually reveal about a client, you made the point that only a subscriber credit report is admissible in court. And
it's the foundation for my opinion.
Yes, and importantly for the lawyers to be useful as evidence if you need to use it as evidence because you're at trial or
Right.
a hearing. You don't need to worry so much about what's admissible if you're only talking about settlement, but you can't really talk about settlement if you're not maximally ready to go to trial if need be, and being ready to go to trial means having admissible evidence. That's where cases are sometimes won or lost, whether you get the evidence in or not.
Right.
So subscriber credit reports what is admissible and nothing else. In the Sunday paper, the financial gurus, they say, get an annual, credit report from one of these sites. And that's not what you're talking about with a subscriber credit report, right?
Your demand will be not admitted if you use that kind of foundational document. I will not use them for anything that may wind up in court
Okay,
because it won't be admissible.
got it. So, assuming that you've got your ducks lined up and your documents are being admitted, the subscriber credit report that you've obtained, what does it really show then?
Well, first of all, it should say that consumer credit reports, which is what we're talking about here, okay, and we can address the issue of business credit reports, which are totally a different situation. But in consumer credit reports, the period covered by the report is the previous 7 years of credit activity. So we are able to establish the level of credit usage by the client prior to the injury and as a baseline, and we are able to compare, point to the date of damage when the information first appeared, the derogatory information, and then we are able to, through an additional current credit report, confirm to the court's satisfaction that the problem still exists or it doesn't still exist. Because the problem still does not still have to exist to be compensable. It simply had to be present for a appropriate period of time. So if the let's take the personal injury matter. If the client was out of work for 60 or 90 days and late payment remarks, which are the most common derogatory remarks, appear in the credit report, they're going to be there for 7 years. That damage is going to be, and that's the statutory limitation of remarks from the date of the remarks occurrence. The Fair Credit Reporting Act stipulates it can only be reported from the 7 years from the date of activity, except in the case of a bankruptcy, which can remain on the credit report for 10 years. And let's go to the questions to ask the client. Some clients are very embarrassed to tell anybody except their spouse, sometimes their kids, but they're very embarrassed to tell anybody, we're not keeping up with our bills. And they somehow are reassured by the attorney that when the case settles, everything will be terrific. Well, that's not true. If the credit damage amount is not included in the settlement, then it's incomplete, because for the 7 years that the derogatory remark is there for any subscriber to look at, they are allowed to use that information at their discretion in approving and denying the application, whether it's for credit or insurance or employment. And that's going to have an impact on the lifestyle of the client. I had a case recently out of Washington State where the client was a victim of their lender not paying the insurance premium on the property, and the insurance premium was on an impound. It was the lender's or servicer's responsibility to make those payments. They did not tell the client that they missed the payments. At the end of, I think it was 12 or 13 months, they sent them a refund without it was a check for over $800, and that without any explanation. Well, the client said, whoop-de-doo, I got $800. And soon after, she got a notice saying that her policy had been canceled 11 or 12 months ago. And when she tried to find new insurance, by the way, in the interim, the lender servicer had put forced insurance on her property, but only for the mortgage, which is not unusual. And so that covered the financial aspect of it, but it did not cover the residents' insurance needs. And when she went out to do some remodeling on the property, she started doing this about 2 years ago, and she got bids from everybody, and because at that time the policy was enforced and everything was good. And when she went back a year and a half later, all the costs of doing what she wanted to do had risen to the tune of over $100,000. And if that had not been included in the settlement of the case, she could not have done any of that work because the statutory violations were of nominal economic value. The impact of the non-payment of the insurance premium, the inability to get new insurance on her own to include all the factors that had been in the original policy, all of a sudden she would have to give up the lifestyle that she had, which included horses and dogs and rescuing critters. And she was really very, very upset that she was going to wind up not homeless, but in an apartment rather than in her own property.
Well, so it's you know, these cases of claims of credit damages in the olden days were kind of getting kicked out as speculative, and the tide has turned. So
well, I believe that one of the reasons that the speculative label was pinned on by the defense is because they wanted to confuse the issue. They did not want there to be any additional compensation that the insurance companies would have to pay out based on measurability. One of the most ridiculous comments I've ever heard is that if you foreclose on somebody, there is no economic damage because the property value was less than they paid for it, or they hadn't made payments, which is a different issue. But the value of the property has nothing to do with the reputation of the borrower. And so there's become a clarity of what's applicable, what's measurable, and how should it be measured and included in a report to be able to guide the attorneys and the judges and arbitrators into being able to see, oh yes, well, the cost of whatever the problem is has gone up, the opportunity for credit has evaporated, et cetera. I was involved in a case, and this is another application. I was involved in a construction defect matter in California, and the matter was a condo conversion that went bad, and it was out of, I think, 8 buildings. One building was the sole problem, and of that building, I think there were 12 residents, and 4 of them wound up being clients of mine. And the damages to the clients were they had to vacate the property. 3 out of the 4 had to vacate the property. So they were involved in double residency costs. They were involved with replacing ruined furniture, and it was a water problem, and in some cases clothes. And the damage was very specific as to what the damages have been and for what time period. And when it was given to the arbitrator, he looked at it like it was from Mars, but he saw that there was some logic to the damage, that there was damage, and the compensation, the economic damage ranged for the 3 clients that were there from a high of about $270,000 to a low of about $45,000. And the arbitrator recognized for the first time in California that credit damage could be, and in his case was, awarded to the residents of the property, and he just, so that happened. So again, construction defect is another new category of type of case that can include credit damages.
We mentioned how credit damages can really affect the value of a case, and that's why it's important. Another reason, though, is the standard of care. I mentioned I get involved with a lot of legal malpractice cases, and they've changed. They're not blown statutes of limitation and deadline cases like they used to be. And there are a lot of cases now where lawyers have been sued for a case which was settled, but the client was unhappy with how much was obtained. And so it's another good way to protect yourself. If you've explored the credit damage aspect in a case and you've got a report that shows that it either was or was not viable, how much more thorough could you look as far as having protected your client's rights and maximizing the value of the case? At that point, the client who actually has sued, if that's the case, is left with the argument of, well, I agreed to the settlement, but I just didn't think it was enough. That's not a problem for you as a lawyer. If you've got a credit report and a credit damage expert opinion, you're gold. So another good reason to look at this aspect in any case where it's a viable claim. And that's from the perspective of a defense lawyer or a plaintiff's lawyer.
So Jim, I want to thank you for having me in this presentation, and we will accept questions from listeners, and we will try to answer them individually. And I look forward to your questions.